Hi, everyone. Welcome to TQH and Your Stories discussion series on reshaping India's data landscape. This is the third stakeholder discussion that we are doing on the Personal Data Protection Bill 2019. This discussion comes at the back of the Joint Parliamentary Committee's recommendations on the PDP Bill 2019. The committee submitted its report in December in the winter session of the Parliament. They have, in fact, proposed that the PDP bill now be called the Data Protection Bill, and they have submitted a version of the bill that the committee thinks should be presented to the Parliament. Today, we're going to discuss on what this new bill, as proposed by the Joint Parliamentary Committee, means for the industry and for tech players, both Indian startups as well as foreign tech players in India, and what it means for doing business in India. I'm joined by a panel that is representative of a wide spectrum of entities in the Indian ecosystem. I have Ashish Agarwal, who is the Vice President and Head of Public Policy at NICOM. I have Kailash Nath, who is the Chief Technical Officer at Zerodha. We have Sijo Kuruwala George, who is the head of ADIF, which is Alliance for Digital India Foundation, and we have Neha Chaudhary, who is a part at Ikigai, which is a law works with a lot of tech players in the Indian data ecosystems. We'll also be joined by Ms. Priyanka Chaturvedi, who's a Rajya Sabha MP and is on the Standing Committee of Commerce. And she has been speaking about the bill at various forums and takes a keen interest in tech policy. So while we get into specifics of, what could be the concern of the industry in data protection bill, what we would like to know, I think, Kailash, why don't you go first as somebody who's, I guess, bread and butter is to look at, managing data of so many investors who invest through the Zerodha platform, many of them being my friends. What does data protection bill mean to you, the new Joint Parliamentary Committee's recommendations?
So I'd say we are in a bit of a unique position here because we've always had quasi-data protection, cybersecurity regulations that we've had to adhere to, things prescribed by SEBI. So in the capital markets, I would say there's a really solid technical and legal framework already. So we kind of have a glimpse of how things might be. Now, the big talking points like data localization, personal data, non-personal data, sharing of data between entities, all of these are already at play in capital markets. So every bit of information that we collect as an organization in the bill's parlance data fiduciary, we already upload it to many other regulated entities as stated by regulations. So the copy of highly personal data and financial data goes to, it goes to SEBI, multiple stock exchanges, depositories, KYC data goes to KYC, KRA. So we are already in the thick of these things. Now, with regards to the bill, what from our understanding, and it's a very preliminary understanding, is how exactly the bill, the proposed bill, will play with the existing regulators set by SEBI. I understand we also have an NBFC arm, which is regulated by RBI. So we answer to like 6 different regulators all in all. How do these existing regulations merge into, the larger regulations? Certain points may be contradictory, certain things, directly overlap. A lack of clarity right now. Although, like I said, we kind of have a gist, we understand how all of this might play out because we already are subject to some version of it. There's no clarity on how it will work with existing regulatory bodies and regulations. So that really is the biggest, that's what we are really thinking of right now. Not exactly compliance, because we're already complying with, countless regulations. And of course, the increased compliance burden is another thing. Like I said, answering to 6 regulators in itself is a humongous, process of compliance every year. numerous things that we have to comply to. Now, would there be more? Would they be amalgamated into a larger, framework? We don't really know. So right now, it's a lot of haziness in our industry.
I'm sure, Kailash, nobody envies you at this point, having to answer 6 regulators, and this is going to be a super regulator as well. Great. So actually, Ms. Priyanka Chaturvedi has joined us. So ma'am, thank you for joining. Just before you joined, we were hearing from Kailash, who's the Chief Technical Officer at Zerodha, on what this data protection bill means for the industry and for people like him, whose job is to keep the data of their users safe. But ma'am, given that you are also on the standing committee of you interact with businesses and various actors in the ecosystem, we would have to know from you, as a member of parliament, where do you see this bill going from here? And what do you think of the JPC's recommendations on the data protection bill? What do you think, how do you think it may impact the ease of doing business in India and generally impact the rights of data principles in India?
I think our concern, my own concern, though I was not part of any of this joint parliamentary committee or part of any IT committee, unfortunately. But however, I have a very strong opinion with regards to how non-personal data and personal data have been clubbed in the personal data protection bill. I have tremendous issues with the way government is totally absolving itself of accountability and responsibility, and under the garb of national security and threat against the nation, they think that it is absolutely okay to snoop on people's data, which I think is unfortunate. The second, about ease of doing business, I think ease of doing business should also mean that while of course we are facilitating businesses to flourish, at the same time we are also expecting some kinds of compliance. For example, many businesses these days, and under the garb of customer relationship management, they take your mobile numbers, they take your Aadhaar card, and they use it for their own purposes. And they enter your, nowadays, some companies, some well-known established brands are part of, they just feel free to WhatsApp you information that you haven't solicited. They send messages to you which you haven't solicited. So the crime, unfortunately for a citizen, just having to share information becomes an all-pervasive kind of a certificate that we're giving away, that you can use your data in any way they feel fit. And that is where the unfortunate reality lies. And we need to have a personal data protection law which ensures compliance, which is not a hindrance to ease of doing business, but also ensures accountability from these business. And we are creating I would say very straightforward work, which will tell you what is personal data, which is a no-go zone, versus a non-personal data. And I think that differentiation needs to be put into place. The overarching, I would say, access that the government is seeking is problematic, because ultimately it will lead to consequences of our nation as a democracy and our constitutional right to privacy. And those are the areas which needed to have been looked into more sensitively, and which I think this bill in some ways has failed to do so. Once it comes up for discussion, it's a report that has been submitted. Once it comes up for discussion, I'm certainly going to raise these concerns that I have in mind. So while accountability from business is one thing, accountability from the government in terms of your data is extremely important.
Right. Thank you, ma'am. I think very useful comments. I just wanted to check. So you mentioned that you have a problem with non-personal data, personal data being clubbed together. I think a lot of businesses are also concerned that non-personal data, when it comes to how it should be handled, etc., there is no international sort of precedent in terms of how it can be sought, how do you treat it, and also when does data transform from being not personal data to non-personal data. So do you think that when it comes to the industry, I mean, in your view as an MP, have you heard from companies, or do you think that is something that should also be thought through? How would what kind of compliance burden it may put on startups and small digital companies, and whether they will be able to cope up with this kind of a regime.
Absolutely, that is one concern which also needs to be kept in mind. The bigger giant get away by having a compliance officer, compliance requirements that are needed. The bigger strugglers would be those who are just starting out and are given a lot of do's and don'ts on how to wade through their businesses and ensure that they are managing to not violate the data protection laws. This is, of course, any bill that is discussed or any report that is created is on the basis of various stakeholder discussions and keeping their concerns in mind. I have been approached, of course, by PAFI with regards to this particular thing. I've been discussing with them. But at the same time, I also feel that there needs to be, I'm also of the concern that there needs to be some kind of accountability set in businesses. Maybe we can ease the load that is expected, or ease the number of compliances that are expected out of the smaller companies. But in terms of ensuring that a citizen's rights are not violated, because data has become oil, the new oil, that as many people like to say, data has also become a method to gauge customer preference and customer choices, etc. So how much more are you willing to let go in terms of identifying, and also algorithms that push some ideas to you because of the choices they, by going through your data sets, they've managed to figure out how it works. So I think that should definitely be something we look at in terms of compliance, but make it the rules in such a manner that it's not a hindrance to businesses, especially small businesses. On one hand, we're talking about Startup India, we're talking about unicorns that we are creating, but at the same time, we are burdening them with so much compliances that are needed and the do's and don'ts that are needed, that makes it unviable for them to unleash their potential. So we need to definitely look into that. And I'll be absolutely open to the idea of anyone coming and consulting me on this and taking this up. Because any law that comes into place can lead to outcomes which are unintentional, but can also prove harmful in terms of job creation, in terms of economic growth, etc. So I'm open to that, but I also believe that compliance is needed.
Thank you, ma'am. And I will bring in Sijo here, who I think sort of represents the voice of Indian startups, both which are, I guess, smaller in size and newer, and also bigger startups. So Sijo, any thoughts on, what ma'am was just talking about in terms of ease of doing business, smaller startups, etc.?
No, absolutely. Just to build on to what Madam just shared. See, at the onset, just to build on what Madam said, and also to some extent what Kailash also started touching upon, right? There definitely is a concern of compliance and issues related to compliance, sort of bogging down Indian startups, be it small startups or big startups, so in comparison to their global peers, right? And startups these days actually compete in a global market. They don't even compete in a Indian market, so to speak, right? In such a scenario, any sort of over compliance burdens, especially on younger startups, will prove extremely detrimental. Now, there are aspects of it if we were to again break it down. Now, one of the simple aspects of the fact that if you look at a very young startup, right? I mean, a startup is typically a bunch of young individuals sitting across a table and trying to brainstorm. And predominantly and ideally, we want them to be completely focused on their customers and building out the service and products and stuff like that, right? Even in the present reality, we have a situation where even a very young startup has to work through a lot of regulations in terms of what paperwork, what month, and everything. But in the eventuality of the data protection law coming in, right, and with all the norms related to, let's say, localization and storage norms and everything, right, a lot of young startups may not even be aware of the kind of requirements they actually have to go through. So that itself is going to be one major chunk of concern. The second part is the fact that they actually will result in a situation where the compliance costs will go up, however small or big it may be. There definitely is an increase in compliance cost. And third is again a part that should not be completely missed at all, especially companies that operate in the internet economy, the global digital economy. you actually tend to leverage a lot of other tools and services and resources to actually build out a product. No product sort of stands in isolation, be it a server, be it subscription service that plugged into it. And just as an anecdote, if I were to mention a small data point, an e-commerce startup, which is like a seller pretty much, and one or two assistants, even if you have a basic website on WordPress, which is completely open source, so to speak, you're looking at least 20 to 40 plugins on average each small outfit is actually using, right? And all these plugins are actually from companies from across the globe. So we are in a situation where either our companies, our young startups will end up using services which are non-compliant, putting these companies at a risk of their own. On the other end of the spectrum, you have a situation where a lot of these global players might decide not to do business with companies in India, especially young startups and everything, which further disadvantages them to the point where you're sort of plugged out of the whole economy as well. So that's a larger frame in which we should look at it. I think all of us in particular agree that this is actually a welcome move on the part of the government in terms of saying that, hey, we need a regulatory framework in terms of looking at data and having a patient data protection thing. So that's a very welcome step. But having said that, in the current format with the thinking and the discussions that are going in, are we trying to do too much too fast? Should it still be a very graded approach, keep a very light framework bill? And at this point, and that's where I want to just reference my friend Kai, to some extent, the present and the JPC comments around it sort of raises more questions than it answers. And that puts a lot of uncertainty and anxiety, especially in the startup community, and how it's going to manifest given the fluid nature and the dynamic innovative nature of how the internet or the digital economy works. That really needs to be factored in when we look at the approach of how we craft the bill also.
Right. And thanks, Sijo. I'm going to go to Ashish now, who I think represents more mature industries. And Ashish, I think, the industry has had an opportunity to talk to the JPC, has had multiple conversations with the JPC. I think JPC took 2 years and I think listened to everybody. And I think for that, it needs to be commended. But do you think that the industry's concerns have been taken on board, and specifically which are the main sort of sticking things that you wish were handled differently by the JPC?
Thanks, Aprajita. So I think we have had the benefit of a lot of consultation at the government level. It's been like my own work in NASSCOM, I think over 3.5 years, and it's been quite parallel to the entire process since Justice Shri Krishna report came in. But I think one, definitely, I want to underline the fact that this law is going to be very important and we are looking forward to it, just because we think that it helps improve trust in the market, and that's good for business and good for consumers, right? Now, given that, and I would say, Sijo, it's not just startups who are facing the uncertainty, it's also the large enterprises which are faced with uncertainty. So in that sense, it's pretty much, across the board, that probably a challenge which we can share. Having said that, the lens that we apply to this, at least from when I look at it from a NASSCOM perspective, is that about 80% of our industry is export focused, right? And we process world's data. So here's a big opportunity to say that without a law on personal data protection, I think we had the benefit of the IT Act, and that's there. But we have managed to give confidence to over 100 countries to allow their data to be processed by us, right? So imagine what now a law can do, huge opportunity. So that's point number one. And when you think about that, the lens immediately focuses on something as a concept, data adequacy, right? And when you think of data adequacy, it is not just about cross-border data flow. Data adequacy by itself underlines the fact that a strong privacy is going to be essential, right? And when we say strong privacy regime, it's a horizontal regime. So when you look at all of this, I think there is a scope for improvement in all of this, and we can go into the detail of that. And I think all this then finally flows back into a digital trade perspective. And when you think of it as digital trade perspective, so for example, right now, India and UK are at a stage to be discussing the FTA, right? And we are looking at a digital chapter as an important chapter of that FTA. So when you think about that, then And clearly, it's a negotiation between two nations, and there are certain things which we want from UK, and there are certain things we want to be able to offer from India side. So I think the data protection law, what it offers in terms of the cross-border data flow, is going to be a very important thing. And if it has certain challenges, which are going to get hard-coded in the law if it is passed as it is, then what it does for the government and for the industry is it makes it difficult for everybody to actually do what is required. So I think the one fundamental point is that both government and industry need to have certain flexibility when you think of the global context, because we don't know everything at this stage in terms of how it's playing out. So to lock ourselves out of that flexibility through some hard-coded provision, I think that's problematic. Second is that while the law started as something of an inspiration from GDPR, right? Now GDPR treats the data fiduciaries as adults. So basically, they say that, okay, you're going to be making sure you're going to be compliant, and then you're going to justify how you are ensuring that compliance, right? So in India, when you try and start looking at it from that perspective, I think it's a great thing. But so if I just conclude by giving an example, so I think Shijo mentioned, or you mentioned, I think Priyanka mentioned about the algorithm or fairness, right? This point was mentioned. So you already have, let's say, clause 4 and clause 5. Clause 4 talks about purpose, and then clause 5 talks about purpose limitation. And then to what extent do you want to leave it to the business entities to justify that they are doing the processing in a manner which is fair and for the purpose for which it is required? And to what extent do you want to then put down specific prescriptive regulation, which because of poor drafting also lead to a whole lot of uncertainty? So I think this is one bucket that industry is worried about. And second is this entire, the way the NPD has been retrofitted into this law. I think it just causes a whole lot of issues, and happy to talk about that.
Right. Ashish, I think that really puts things into perspective, because, you know, we are not operating in a silo. We're operating in a global economy. And I mean, the idea, I mean, it's government's focus to increase the export. So are we really making a data regime that actually leads to that vision is something to think about. Neha, I'll come to you now, since you are advising so many, I guess, tech companies on, you know, how they could already start thinking about complying with the protection bill. What do you think about the JPC's recommendations? And are there any specific clauses that you hear a lot of tech companies being very, very concerned about, and they think will interfere with their operations?
Thanks so much, Aprajita, and thanks for the invite. Lovely to be here, and really looking forward to the rest of this conversation as well. So look, I think a couple of things. Some companies have definitely begun to think very seriously about complying with the upcoming law. I think especially now that we've seen some movement from the Joint Parliamentary Committee, I think the question has changed to, you know, when we're likely to see something like this go out. Also, increasingly, I think it's once upon a time when it used to be a competitive advantage, I think we're now increasingly moving towards a need to have territory as opposed to a good to have territory, where you know, you're losing out if you're not able to show that you take privacy seriously as a business, particularly in certain kinds of sectors where sensitive information is involved. That said, I think we've heard, and I think we've heard this across the board from all of the clients that we work with, whether they're large companies or whether they're you know, smaller startups, or even some of the larger startups or mid-size, right? I think it's agnostic of the size and scale of operations. One, of course, is the expanded scope include non-personal data. I won't belabor this point. We've heard different people on the panel talk about this, but I think, again, given that it's very, very, very early days in the Indian discourse on non-personal data governance, and I think even in global discourse on non-personal data governance, we've begun to have some conversations about what it is that we need to do with information that's not personal. But I think to look at sort of heavy-handed regulation I think is definitely premature, because it does leave open several questions which continue to be unanswered, which were raised even when the non-personal data committee was looking into this, right? Whether it's questions of intellectual property, whether it's how do you identify where the right is going to vest, who is going to be the owner of this information. There's a lot, I think, that needs to be unpacked. Second, I would say is there's some language here that seems to import new restrictions on cross-border data flows. And again, this is a theme that we've heard come up before on the panel as well, right? It's important to be a part of the global economy. Cross-border data flows are critical to ensuring that happens. So what we're seeing now is a couple of things that have changed are going to make it harder, I think, for businesses to engage in cross-border data flows. One being the fact that it's the DPA, the data protection in consultation with the central government that's now going to issue, that's now going to give permissions for cross-border data flows. Permissions may be refused on grounds of public policy. Policy, as all of us know, is a fairly wide concept, and the meaning changes depending on the context and the policy priorities of the government that we're talking about, right? So that's concerning. Countries may not get an adequacy requirement. I mean, one of the preconditions to getting an adequacy requirement will be that you don't engage in further transfers of data from that point, which is again inconsistent with what we see with a bunch of other frameworks around the world, including the GDPR. There is some potential introduction of a retrospective application of data localization, where the JPC has said that the central government should try and work towards getting back critical information and sensitive information stored abroad. So that's again been something that's been a cause for concern. And I think the third big bucket, there are several others, honestly, but I'll stop with this one. The third big bucket, I would say, is the proprietary rights of businesses when it comes to information. Ashish was making the point earlier on disclosures related to algorithms, talking about algorithmic accountability, but we also see this coming through in the data portability, in the right to data portability, where there's been a hinge where businesses can't now say that, where businesses can't buy the right to data portability on the grounds that it would violate, a trade secret. And this is again inconsistent with what we've seen in countries around the world, where there is a very real risk of whether or not the individual exercising her right to data portability is going to result in the disclosure of proprietary or confidential information, and how are you going to prevent that from happening. If you compare this with the GDPR, the right is far more narrow, and it's limited only to the information that I as an individual have provided to the platform, right? Which is very different from the way the right comes through in India, which also includes information that the platform would have generated about me, because it's any information associated with the individual or that can identify the individual, because personal information is fairly widely defined. Or it could be any information user has generated as a result of interacting with that platform as well. So the right in itself extends to a set of information. That's one. And second is, when there used to be an exception that businesses could avail of on the grounds of trade secrets, the risk of trade secrets being disclosed, that's gone. So I think these would be my top three, but a couple of others as well, I would say.
Great, Neha, thank you so much for listing out, what are the problematic aspects. Ma'am, I would like to come to you as somebody now, of course, the JPC sort of submitted the report. The government will at some point bring the personal data protection bill in the parliament. As you did, and I think there's been a lot of discussion from the opposition around, the fact that DPA has too much power. Central government has given itself too many exemptions. But as you can see, the industry itself also has many, concerns, which not only, I guess, impact, businesses right now, but generally where Indian economy goes from here, because a lot of business is happening with global products being utilized and also as a part of global trade. So ma'am, what do you think? I mean, what would your suggestion would be to the industry to be able to kind of raise these points and make sure that they get addressed? Because some of these things actually were not even in the PDP Bill 2019, but they got introduced after the Joint Parliamentary Committee. So where do we go from here is the question.
Prajita, all I'd like to say is I have been someone who's pro-business, pro-startups, and have been raising their issues, their concerns. And they can be rest assured that all these concerns would be raised not just by me, but a lot of opposition members who are part of the Data Protection Committee, the Joint Parliamentary Committee, have put in their dissent notes on certain areas of concern. And I'm very certain that no law can be passed in a hurry. And we cannot pass something in a hurry and repent in leisure, especially when we have a budding ecosystem coming up where today the Prime Minister himself in the Parliament spoke about the startup culture that India is doing well in. And it is a given that India is, I would say, a global leader in tech space. And we need to, I would say, utilize that talent, utilize that I would say force multiplier in economic growth, and not binded by some rules and regulations which in any way bar free flowing of businesses, free flowing information, data, etc., and holding them accountable every single step that they take in their journey, whether it's at the beginning or it's moving to the next scale or scaling it up. That I can totally reassure them that nothing of anything that concerns them and concerns their businesses or impacting their businesses will be not heeded or not spoken of. Now, having said that, and I was listening very carefully to the concerns coming from all sides, I'm very certain that stakeholders have also spoken to the government bodies about this, and whatever will come, and dissent note would be kept in mind. Whatever will, all of these will be a massive factor in drafting of the bill. If they manage to do that, I mean, if they manage to ignore that, I think they'll do that at their own peril, and we would be protesting it vociferously. But my only belief is that the only way forward is to ensure that our tech industry does not feel stagnated from any end, or is not forced into a compliance burden, which when we are talking about a thriving space, is in any way harmed, and our businesses are forced with having to comply with too many rules and regulations, do's and don'ts, and even at times a lot of uncertainty and a lot of silence that even the report has in terms of intellectual property rights, in terms of data portability, etc. So I think all these concerns would be looked into. And I will raise my voice in case it's not.
Okay, great. Ma'am, if it's okay, after the panel, what we can do is also list down some of these things that we are sort of talking about clause by clause and share it with you so that you can also socialize it a little bit. Sijo, I'm actually going to come to you. I think Ashish spoke about cross-border data flows, and I think for the ITES industry, I think it's a no-brainer that this is something which is an issue. But do you think that, I mean, a lot of data conversation around data localization is being technically done in the name of supporting the Indian tech ecosystem, right, and supporting Indian startups. But do you think that provisions such as these would actually help the ecosystem, or do you think that especially now, given that central government has to be consulted for cross-border data flows, which is clause 34, what do you think, how will that play out for Indian startups?
So in the short term, absolutely, this is going to impact adversely. There are two aspects to it again. So going back to what Ashish said, right? In the industries and the organizations that he represents, it's not as diverse as we actually have, absolute revenues impacted very directly. So in the cross-border data transfer situation, it's going to be a very, a messy affair, in the sense that the internet is very decentralized and very fragmented, right? So the moment any of us use any service these days, including the Zoom for that matter, right? And a startup signs on a G Suite or any product for that matter, it actually is not possible for us to really know where the data is getting resided, right? And going back to the that I mentioned earlier, startups, especially young companies, rely on a lot of tools to actually build out and offer their services, and that too for a global audience. In such a scenario, what is intended to actually create a lot more trust, that is the original intention of this particular bill, and actually create a situation where you can actually have an industry on top of that, right? Imagine a situation where you actually result in, let's say, compliance increasing and also trust also decreasing. And if it's bureaucracy that's coming up on top of everything, right? And I'll probably cite an example which I came across a few days. What's happening is we built what a very, very good momentum that we've been seeing over the last few years, right? In terms of startups mushrooming and the whole sector contributing a lot. We will end up in a scenario where we'll actually have some of our entrepreneurs and companies moving to various other geographies in different parts of the globe because of lack of clarity or ease of doing business or whatever it may be. And the whole idea of being an entrepreneur is that you can play around and innovate and build on top of that. And that particular threshold exemption is not factored into the visualization of either the bill or the JPC rulings, right? So even a very young individual can also be considered data fiduciary. There is no exemption or there is no threshold beyond which that person's or that individual, and it's an individual also, it's not even an entity, becomes under the bill. And that is actually quite challenging to even visualize, right? And even the language is that if you use reasonable computing power. Now, a particular person using a small Google spreadsheet is actually using massive computing power, right? And the kind of data that you have on your spreadsheets, you actually don't know where it's residing, but what all data is actually there on your spreadsheet as well, right? And every other individual, and most people who's familiar with how business happens in India, right? I once happened to speak to a founders in the travel space. Almost every travel agent is operating out of an Excel file. And these are a couple of crores of businesses as well. And the visualization of a very big entity being a business is not exactly true and doesn't hold true here. So it poses huge amount of challenges if you just keep it in this particular form. And as I mentioned that, right, that scope for innovation, that scope for really taking advantage of the possibilities that both the bill in the original visualization, why it was conceptualized, and the fact of what the digital economy promises, that aspect, if it's getting missed out, I think we really missed the bus with respect to this particular bill. And just to add on to the anecdotal thing, right? And Ashish mentioned a few points again in terms of saying that bill by default has to start treating people as adults. At least that was what Gdpr did. Few days back, I happened to read an article which said that NICSI currently is requiring explicit consent if an individual actually has more than 2 dotted domains in their name. I myself has 4 dotted domains, right? And NICSI is a body that is set up to promote a dotted domain. And if I were to make some contextual layer on top of it, I am someone almost every other conversation. People keep asking a .com domain. I sort of like the dotted domain. I'm sort of advocating for it. But at this point in time, if I have to have more than 2 dotted domains, right? And I'm not even a person who's actually flipping domains and getting into that kind of businesses. But I myself have to 4 or 5 dotted domains. And if every third dotted domain that I have to pick, I actually have to put up a request and it gets cleared. And if that bureaucracy comes first, I think we'll be in for a humongous issue, especially if you look at the industry that Ashish also represent, right? There are existing contracts and existing large amount of data, and forget the new opportunities that we can tap into. This itself is challenging, and some of the provisions of the JPs are also a bit challenging, right? From a data provisions, the data cross-border data localization standpoint also. There is a sentence that says that in a time-bound manner, we should actually bring back all the data that has already left the country. Now, what does that even mean? How can you even visualize that? It seems like a very simple sentence, but it actually is. I don't think anybody who understands. Kailash can talk about that. From a tech standpoint, it's a near impossible problem, so to speak. Forget the other aspects around it. So some of those aspects are very challenging, but the most critical part probably want to highlight, especially for everyone in the audience, right? See, for this data protection law or regime on the whole visualization to be successful, there needs to be a full data infrastructure around it, especially if you factor in localization aspect as well, right? if you don't have a sufficient infrastructure as an industry built out also in the country, if you don't give that support, if you don't give the time for that to build out, what is supposed to actually propel will actually pull us back. And the result would be a lot of people leaving shows. Earlier you had people leaving for jobs, but we'll have people leaving for lack of freedom to innovate and play around and build on top of stuff. And with the Web3 coming in, it's even going to be way more distributed and a global internet we're going to see. And that is a framework, in my opinion, is sort of getting missed out in the articulation of visualization, both of the bill and also the JPC report. My thinking here would be in a classic tech speak, right? We are seeing what we call a scope creep. What was thought of it as a very simple bill as a starting point. Currently, we have data localization, which, as Kailash also said, you already have various other agencies already having data localization norms and data storage norms. Even in the GDPR framework, the data localization requirements per industry is left to the respective agencies and not fully brought into the GDPR framework. So a simple lightweight framework which actually helps keep moving stuff. And the notice like Nixie announcements just adds more concern. Now, even in such scenario, right, instead of by default assuming everything is going to do wrong, if you're an adult, and that's what the tax industry is all doing right now, there is massive data capabilities even by the government, right? If that is tracked and over a period of time a suspicion profile is there, then you can check on a need basis as against only approval and default. And that's sort of the same approach that has been taken for, let's say, data to be transferred across the globe also, right? And mind you, a lot of these categories are not exactly defined even yet. What exactly is a critical personal data? On top of that, we have a situation where we want to bring in non-personal data also. So even those areas that were supposed to be defined are not exactly defined. So maybe we should take it a bit slow and those are the areas to look at.
Thanks, Sijo. I'll come to non-personal data in a bit. And thank you for mentioning Web3 because there's no tech discussion without a mention of Web3 these days. Ashish, I am actually going to come to you because I think things that actually ma'am also mentioned is the exemptions and the role that the central government is supposed to play as per the JPC's recommendations. Do you worry that, in cross-border data flows, if the central government is going to get consulted, even for intra-group flows, etc., some geopolitical considerations may actually start weighing in? And I mean, we have seen that with other regulators also a bit, but with DPA, it seems that the current scope of work gives a lot of room for even political interference. And I think on that, the opposition and I guess the industry would be aligned. I think it's in everybody's interest for DPA to be more independent.
Let me try and answer that. Probably I'll use a couple of examples. So see, one of the important things which I kind of mentioned in the beginning is, and which we fully push for, is privacy interoperability, right? And then as soon as you think about that, then you would think that we can't have same laws in all the countries because every country is different and therefore we need to adjust for that. That's fair enough. So what do you need to adjust for in India? You need to adjust one for the state capacity and then our own heterogeneity in terms of how we are, right? So we start doing those adjustments. So let's assume that the formulation in the law is because of those adjustments. And that's where we differ from the global track. So start from the basic data classification. Okay, so now we have something called a sensitive personal data. So our law, where we sidetrack is, we say an official identifier is a sensitive personal data. We say that a financial information is a sensitive personal data. We also say not only health data, but all data collected in the process of provision of services on health is sensitive personal data. Now, as soon as we do that, in our mind, it doesn't relate back to the difference between India and the world, but it is just a difference. Because this is not same as, for example, the difference which is actually relevant is, let's say, caste data. And that we have classified as sensitive personal data because it is a sensitivity which is probably unique to India. But what can you do with my passport number in isolation? What can you actually do to harm me with my bank account number in isolation? What can you do with my insurance application form number in isolation? What these things will do. So there are certain things which they do generally, like take the cost of healthcare up. So talk about that. But now let's say we think of cross-border data flow. We are processing the global data in India. So on the day this law is enacted, all of these restrictions will apply to that foreign data getting processed in India. So then you have a section 37 which says government can exempt certain data processors, class of data processors from applicability of any provision of the law. But as it stands, we don't know what the shape and size of that exemption is. And what we also do is that when we do that, we communicate to the global regime that we are creating a differential regime for processing of Indian data and foreign data, which, as we know in the Privacy Shield judgment, was the reason why that Privacy Shield was struck down, because EU found that US has differential treatment. So now you need to fix that by doing ABC, right? So that's one kind of a problem. Second kind of a problem, which you just mentioned, is consultation with central government. Okay, fine. So we could have a history where we could have experienced in our agency design that maybe, just taken a random example, that sometime government would have felt it would have been good if RBI had consulted or was forced to consult central government, or SEBI was forced, and that's a learning, and therefore we want to make this happen. Okay, great. So you want, and because central government in that sense represents the elected people, I think they have that probably, it's their place to have that right in some cases. But then when you look at our cross-border data flow provisions, each data transfer appears to be requiring approval. So, and then relate back to the problem of state capacity. So if you had a problem of state capacity, then why would you put a proposal which will say that each transfer will require an approval, and on top of it, it will require mandatorily central government involvement? So you are creating a situation, and then you link it back to the requirement that cross-border data flow, you require a double consent for SPD, and you require a continued storage of data in India. So kind of when you look at it in overall context, then you then step back and say that where was this done in the context of doing something which was uniquely important for India, and therefore stepping away from privacy interoperability, and where it is probably not clear the whys and hows of this. So in that context, I think we seem to be into some sort of a lot of band-aid fixes now, which will at least not make it look elegant in sense when we are looking at a law. And I think that's the kind of challenge that we are definitely talking about. And I think, and just I want to touch on one more point before I stop, and which Kailash mentioned in the beginning. So industries dealing with multiple regulators, I think that's par for course, right? In the sense that's fine. But so for example, one of the expectation is when the data protection law is enacted, it will set the baseline of how we think about privacy protection. So today, all regulators could potentially go in different directions, right? We had some issues when RBI decided that payment data has to be only processed, kind of stored only in India, and even if it is processed, it has to be brought back. Okay, fine, RBI thinks about it in a certain manner. But now what this bill is saying is that if you are a significant data fiduciary, then you could be regulated by a sectoral regulator. So which means on data, you could be regulated by a sectoral regulator, which means then so it also creates some incentives. So for example, if I'm a data protection authority, I could say, okay, fine, if I put a certain threshold and have certain people as significant data fiduciaries, then they're out of my purview. So I don't have to regulate them. So how does that incentive work? Second is that once you put them out, then will you come up with a situation where then you will have these multiple regimes which government, which industry will have to deal with, right? So I think some of these things, I think require some deliberate thinking, a use case scenario based thinking, not a theoretical thinking. I think you need to look at some real world examples and see how this plays out, and that's what we are trying to do. And hopefully that conversation, I think, will happen with the government, and these things can be fixed.
Great, thank you, Ashish. I think you make a very, very good point about state capacity, and I know that you work with NIPFP, so I guess that's where probably this is coming from a little bit. But I'm going to come to you. I think DPA, I think a lot of people have raised this. The way DPA is designed right now, do you think it has taken more than what it can possibly chew? And what do you think, would be like some of the day-to-day hassles? And just in terms of the regulatory design, I don't know if you've seen other countries, and do you think there's a parallel to what we are envisioning our DA to be? Or have we just expanded the mandate too much and, we are expecting too many, I guess, decisions from them, even for small things?
Yeah, I think again, that is a concern that we've heard come in from several people, including the industry, and of course, folks that have been studying regulatory architectures in far more greater detail than perhaps folks in the industry. And I think, yes, the challenge of state capacity is a very, very real one. Also, I think different questions have come up in terms of practical implementation, right? Where are you going to locate the DPA? How are you going to ensure people have access to the DPA? Who are going to be the people that make up the composition of the DPA? You want somebody who's going to have, who's going to be independent at the same time, is going to have the expertise and the experience to deal with difficult and tricky questions of data protection, which I mean, we're still grappling with. Several regulators around the world are also grappling with. And I think what something that we've seen since the very beginning of when we began to have conversations on the PDP bill in India, going back to 2018, I think the ask has always been one for a consultative regulator that works, that's accessible to different stakeholders, that relies on inputs that it receives from different parts, from different stakeholders, particularly on questions of implementation, since that's what we're talking about today, listens to the industry, because they're the folks that, that are actually taking care of the implementation on a day-to-day basis. So what you don't want, which we see very often with several other regulators in the country, is this sort of, we've identified the problem and we're also now going to come up with a extremely sort of prescriptive solution for you. And this is what you will have to do to be able to comply and to be on the right side of the law. What you want instead is to be able to have a regulator that's able to identify the problem and say, hey, can we now work together to figure out what a solution might be? For instance, I mean, this is not necessarily a DPA specific point, but there's a new thing in the Personal Data Protection Bill that talks about this new certification for hardware and software products, right? I mean, I genuinely don't understand what that's about, because if products are already complying with best-in-class global standards, sure, understandably that privacy and data protection, you want to make sure that you're dealing with good products and good services. But again, if I'm already complying with best-in-class globally, what is the need for this extra layer of certification, right? So this is not the kind of prescriptive thing that you want to see from the DPA at all. What would help is principles. Really, that's what legislation should focus on. What will help if there is a model where codes of practices are encouraged and adopted. So a sort of co-regulatory framework where you say, this is how we will give effect to these principles that you're concerned about. As opposed to, I think, the form that we see now, where again, you're going to see either rules prescribed by the central government, or you're going to see regulations that the DPA will come out with. So I do think that there is some heavy-handedness there. And the minute you have heavy-handedness and the minute you have the regulator thinking in terms of prescribing themselves, you're not going to solve the problem of state capacity either. So, which then leads back to the question that you began with, right? Are we looking at burdening the regulator with a lot more than it necessarily should be? And I think in early days, what would be lovely to see is sort of lay the groundwork, establish the principles, get the law up and running. And I think that's honestly something that that should be the focus of the regulator, because I don't think it's humanly possible to do everything that they're expecting the DPA to do. It's just not to happen.
Right.
So
great. And I think, Neha, that makes sense, because I think all of us are data fiduciaries, as it applies to individuals, it applies to two persons, companies, etc. And I think I guess we are not approaching privacy from a place of trust, but from a place of, oh, let's catch people who are doing some something wrong. Sorry, Miss Priyanka Chaturvedi has to leave. So ma'am, before leaving, if you have any closing comments, we'd love to hear from you and then we can
So
continue.
apologies that I am having to leave the discussion, a very interesting discussion. However, having said that, I was listening to, of course, the layers that are needed and the differentiation that is needed, and how there will be a compliance burden and how agencies will be overburdened with all the compliance that they'd be expecting you to do. So it may seem, what seems unviable to us, and also something that even the opposition is talking about. This government has gone and done things and having to withdraw it. So let's hope for the best, but let's plan for the worst. So as far as we're concerned, and the expectations that are expected from the businesses, will ensure that there is a win-win situation, and we are not thwarting businesses, or we're not thwarting ecosystems that create such businesses that will, like I said, a force multiplier for our economy. So that be rest assured. But however, sometimes unrealistic things also get passed, and we need to keep fighting for it. So thank you so much for having me over.
Thank you, ma'am. And we'll keep engaging with your office, and we'll be a detailed list of things that we
Thank you so much. Thank you. Bye.
Kailash, sorry, I'm going to come to you. I know that you've been listening to all the conversation here, but just as somebody, whose sort of like job is to see how data is kind of managed, I want to ask very specifically about NPD. Do you think, how do you think that will impact your operations? Especially given that I think all of data is of extremely sensitive nature. It's already financial in nature and it's heavily regulated. So if this NPD regulation sort of, if the bill gets passed, how will that kind of play out for a company like yours? And given that, there will be mandatory, it has been proposed that there might be mandatory data sharing requests on non-personal data, how do you think you will be able to handle this?
This is something I can answer clearly without any sort of conflict of interest. There is not one bit of information that is really private to us. Every bit of information that we have, all the financial data, trades, assets, holdings, bank balances of, trading account balances of clients, absolutely everything is sent to multiple institutions every single day, some in real time and some in bulk at the end of every day. So this is how this industry has been working. And over the last 3-4 years, the amount of data that we are sharing, maybe sharing is not really the word, it's close to 100%. So we have nothing else to share or keep private really in this industry. So that's why there's no conflict of interest here. When I say that, I think one of the biggest sources of confusion, perplexion, and complexity right now seems to be the conflation of non-personal data with what was meant to be a data, privacy plus personal data protection bill. And if NPD wasn't bundled into what has now become sort of an omnibus framework, this discussion would have been far simpler and far more concise. I agree with everything that's been said here. And really, I think that the problem of non-personal data here in the proposed draft is it's very fundamental. There is no definition of what non-personal data is. In the beginning, the comments say that because it's very difficult to separate non-personal data from personal data, so we'll just have, we'll just roll everything into one framework. Just bits and bytes. I could go write a computer program that generates a weather model which generates billions of rows of data for temperature predictions for the next 1 year. Suddenly a big data set that could be valuable to our business, a particular organization. Now this is other thing about data breach. Let's say I accidentally share this giant Excel sheet which I think is really valuable to my business with somebody else. It could constitute a breach. Now what is the harm being done here? Who are the affected parties? Who's the data principal? These things are all undefined. Most information, we'd like to say that, this is the data economy, data is oil, but most information out there is really junk. Even, significant parts of personal data that businesses amass and the secondary data that they generate from personal data, most of it is just, junk. It's in some vague hopes that you can derive valuable business insights that people keep it. But there's this whole class of other data, which should be probably, I don't know, 90% data, which is absolutely not personal at all. I know traffic patterns, weather patterns, could be anything, absolutely anything. And what exactly are we even protecting? Just bytes, undefined bytes of undefined criticality that does not affect, let's say, the state or sovereignty or the privacy of citizens. So just by bringing NPD here, I think the scope creep is a great word, like Sijo used. It's just complicated, absolutely everything. And I think it has also diluted what should have been a heavy focus on sensitive personal data. And because of this very fundamental confusion and undefinition, the amount of the lack of clarity it brings for citizens and data fiduciaries, businesses, has just exponentially increased. So we can, as I said in the beginning, there's a lack of clarity about everything, but I think it's been exacerbated exponentially because of the conflation of non-personal data, which is just bytes with personal data. So yeah, that's what I have to say. It shouldn't ideally have been brought into the purview at all. I'd like to raise one more point here. Again, no conflict of interest here. As I said, we share everything with multiple regulators, every byte of information. There also seems to be a fundamentally incompatible conflation of terms like digital economy, valuable data incentives, with the whole idea of protecting private data and even protecting data that is just bytes. Personally, I think that these concepts are fundamentally incompatible. The incentives are completely misaligned. If you're talking about digital economy, a lot of the stuff that happens is to derive economic value from personal data. So how could a bill that is framework that is supposed to protect personal data also in the same vein talk about boosting the digital data economy? These are all very different problems and should be tackled separately. There's this one last point that I'd like to add, and that's to give an example to what is an actual example to what Neha was talking about, which is of capacity. So SEBI came out with this data protection, its own data protection for cybersecurity bill in 2018. The first draft had lots of technically impossible things, but SEBI is a very consultative, collaborative regulator. So they constituted a committee with proper experts, the industry, and the industry and SEBI co-wrote that bill. But of course, the regulator is the regulator, so there are still some technically challenging points in there. One of those things was, one of those clauses said that all software, which is critical to businesses in capital markets, which is vended by third-party vendors. If Zerodha is building its own software, it's exempt. But if we are contracting software from another vendor, it should be STQC certified. We'd raise this point over and over, saying that that certification really help, dynamically changing softwares. Software changes every day. And it was of no benefit in terms of cybersecurity. But, the regulator being regulator, it passed through. Of the 90% great things that are in those circular, there's 10% things that are, very unclear. I don't think a single entity has gotten that certification in the last 3 years. Nobody has heard of that certification. There are very few, STQC labs, and the process of copying your source code, sending it to them, getting appointments, sending CDs with your source code, and your software could be written in 1 million different kinds of technologies and programming languages. There's no capacity to look at it and understand it. And SEBI does not seem to be enforcing it because I think it's unenforceable. It's been three plus years now. Nobody has gotten that certification, but it still stands out, that point, as a sticking point. So there's definitely going to be a huge issue of capacity, because some of these things are deeply technical and require deep technical expertise. And it's not something that can just be, legislated or regulated into action.
Thanks, Kailash, for sharing that example. I think it makes it very real and makes us look into the future of what we, the whole industry will be sort of dealing with. And I think you're absolutely right. How do we even build the competence of the regulator to be able to legislate on something and be consultative? And given that you're saying that the software keeps changing almost like every day, so are we sort of, by designing DPA in a way that it has so much on its plate, actually thinking of the impossible? So I'm going to close this discussion. I'll just take last comments from everyone. I think what I'll let you what I would love to hear from you is, where do we go from here? So we know that the bill, of course, is now with MeitY, and they may or may not accept, all the recommendations from the Joint Parliamentary Committee. They can choose to disregard everything, but it's unlikely. Having seen the Parliament, it, I think, brings a lot of shame if you don't accept anything from the committee, and they've spent 2 years. But where do we go from here? So there are clearly some issues that are good to have, but there are some issues which are very existential in nature, right? And there are these foreign trade agreements that are under discussion, and I think a lot of I think digital economy, I mean digital trade is something which is a big part of it. So what can the industry do now? And if you had like a wish list and you could only get 3 things fixed in the PDP bill, what would they be? Ashish, do you want to go first? I feel like you've thought about this a lot more than everybody else.
I think so. We have to, we can't go to the government with 100 things to fix. I think that would be, in some sense, losing the focus. So definitely, I think from here, given the fact that this law is so important, there is an incentive for the government and for industry to do everything possible to get it right. And that gives us a lot of optimism, right? And given that, and there is a lot of alignment in getting it right. These are not issues where there is some kind of opposite pulls and pressures so strong to say that, I think the challenge is the complexity of this law and all of that. And I think the JPC kind of a format, we have to think, when we think of technologically advanced complex topics, how do they need to be strengthened to get this right? But having said that, I think for us, clearly, one of the first thing is just making sure that in terms of privacy interoperability, we can get as close to a global benchmark. And I think that in our mind will also address the inherent privacy related challenges within the law. And I think the second thing is this, the whole, this inclusion of NPD. So while if I were to give credit to the government, I think the thinking that ultimately they want to have one authority is something we can always debate, and we can say far out, whether it's a good idea or a bad idea. You can debate both ways. But having put it in the law in the way it is, and then in the future, maybe amending chapters or coming out with some executive policy and all of that. And I'll just give one example. So even the thing about this hardware monitoring and all of that, right? Data breaches, and breaches cover both NPD and PD. So then the entire scope of this law in that sense kind of probably not been thought through. So I think that bit, some clarity that how they wish to roll out NPD in this framework, if they don't want to recall it completely, I think will also give some clarity to the industry.
I think, Ashish, you were very smart by saying that you should bring the law close to the global data regime. I think in one wish, you've kind of had maybe close to, I guess, 50 things that need to be fixed in the PDP bill. But we understand. I mean, I think the idea is that, you need to be able to trade with the global economy, and how does one do it if the Indian data law stands out so much. Sijo, the same question to you. What is your top things that you think addressed in the law?
So if I take a top 3. So the first thing is, I think this conversation and this bill, the draft has been, we definitely would want to see a timeline by which we'll have something in law, right? And that's the biggest uncertainty for everyone. Is it going to come? Is it not going to come? And from that standpoint, right, if I were to explain the same thing, the first draft or should be something simple. The base of it was the fact that people should be aware what their data is being used for, and that there should be consent. Those are the two primary principles around which we started. So a simple framework starting is probably the first top of mind in mind. The second thing is, as I think the approach has shifted a lot more to compliance. I think it's a beautiful opportunity for us as a country to sort of take this as a starting point for awareness building, capacity building, and really equip the entire country, not just citizens, right? Business, everyone, to a different information age sort of an economy. So, and that aspect is sort of entirely shifting to more and more regulations. So to just take a reference, which Ashish mentioned, now we're looking at using band-aids to sort of fix something which we overreached in the first place. So simplifying and making sure that we actually have an awareness and capacity building approach. Even JPC has sort of acknowledged that, saying that, hey, we need to make sure that we give time. But the time frame JPC is given here, I think it's very important. I mean, business should be given 2 years. The country should be given at least 5 years, right? And that's a kind of real-time learning also we need to understand on how to optimize for that. Retaining the agility, what Ashish spoke about. That's true. Third, I would absolutely bat for leaving out the NPD part. That has been one of the industry's earlier views also. Maybe theoretically, and I'm sure a lot of us can understand this, right? So most CTOs have this notion that, or founders also, my one platform will solve for everything. While as much as we would love to see that as a reality, that more often than not, that's not how it works, right? So that notion is great, but I think we should have a very agile approach to even visualize the DPA. It can't be, so just going back to what our fellow participant mentioned earlier, Neha mentioned earlier, it can't be a very prescriptive sort of an approach. And just to add one point there, the complexity part, we're talking about it, and Kailash can validate this, right? You add one feature, the complexity grows up exponentially. And we've already added 4 or 5 very, very contentious, tough problems. And these tough problems, and all of us are not shying away from the fact that these are tough problems that we need to really find answers for. Nobody has a right answer. But wishing that somehow magically an entity will figure out all the answers in real time is not a great thing. So a very staged implementation where NPD is looked at a much later point in time is something as a third point.
Great, thanks, Sijo. And I think absolutely. And I think maybe what Neha was saying also feeds into that although, of course, DPA, I mean, the law cannot answer everything at this point anyway. So the DPA will have to, keep on making rules, but it needs to be through a very consultative process.
Forget the law. Even the most innovative companies are struggling to, find out these answers, the researches and everything. So yes, we'll need time.
Great. Kailash, your wish list as somebody who actually has to implement anything that the law brings in.
Pretty much exactly the same. These are all, as a citizen, maybe as someone from the industry, there are several individual clauses and sub-clauses that I don't agree with, but that's a different debate. But I think this entire thing is too detailed, too non-technical, which tries to bring in technical and non-technical regulations on defined and undefined, well-defined and poorly defined things like data, personal data, and non-personal data. I mean, non-personal data is basically everything, all data ever created apart from personal data. So my biggest number one item, I only really have one item in the wish list, because as I said, the rest, there are too many things up for debate. Non-personal data should be pried out. It just does not seem to belong here. It seems to be fundamentally incompatible, and it just complicates everything. So even to have a fruitful discussion on the actual clauses and sub-clauses, I think NPD has to be separate, and this whole thing has to be simplified significantly forget discussion, for actual meaningful implementation. And this is a lesson that we've learned over and over in capital markets, firsthand. There are circulars that come in the right spirit. SEBI always works in the right spirit, but they turn out to be technically infeasible, and there are edge. Then an amendment comes out, another amendment, and it keeps on rolling back. That's because I can imagine that capital markets is actually a small industry with just a few thousand, let's say stock brokerages and other entities. Here we are talking about every bit of information created within the boundaries of the country, right? So the scope is insane, and there is no one system or body or one set of bullet points that can understand or encompass such a vast, complex techno-political, social, legal system. So it has to be simplified significantly, and NPD should be separate. Yeah, that's my biggest item in the wish list. Yeah.
Thanks, Kailash. And if I may add, capital markets, I mean, is also, if you have seen that experience with capital markets, even though it's a small industry, but also technologically very advanced industry in some sense. And, the regulator is very mature also. And I think what you're saying also then supports Ashish's point that given that, we have seen certain regulatory regimes being already tested out over the past few years, it's actually much probably better to be as close to them as possible because, the world has had certain experience with them already. And I mean, we know how they kind of pan out. Thank you so much, everyone, for giving your time to this. We will be collating some of these things. I think I think the key things that I guess everybody's spoken about is just, I guess, the ambit, the capacity of the data protection authority. Will it actually have, that much time and capacity to be able to approve all kind of border data flows, etc.? Has taken too much on its plate? NPD, of course, is something that I guess everybody agrees with, have been best left out of the PDP bill. And I think a bunch of other things also came in, such as, just approaching a place of trust versus approaching from a place of mistrust, and then asking for disclosures of algorithms, etc., certification of products, and also then increasing the compliance burden so much and what impact it can have on, in fact, even at QH, we work with a lot of companies, and we have been in discussions where companies are actively not trying to introduce, certain products in India because they don't want to get qualified as significant social media intermediaries, or, they don't want to be touched by a regulation. So we can see very clearly how regulation can actually stifle innovation, and it's already doing so. So thank you so much for sharing your views, and we'll be in touch about the representation that we send on the basis of this discussion. Thank you.